What's up, guys? Welcome to a rare daytime Rescue Michigan live stream. I couldn't wait another moment to share this with you guys. And tonight I'm going to my county Republican Party's after Christmas party. So this is completely unannounced. I'm not expecting there to be very many folks in the chat because we almost never do a stream during the daytime. But it is here, the long-awaited reply from Comerica Bank to Kristina Karamo's insane lawsuit, which we've of course been over a few times in some previous streams, but now we finally have heard back from Comerica. Let's see what they have to say. This is going to be very, very, very funny, and I'll try not to take too long with it. It's about 20 some pages and change. It says 29 pages in the document. That includes some cover sheets and things. Like this is just the sheet, announcing their response. We can skip past this stuff. None of it's really very important. This is where we go here. Okay. So we start. Defendant Comerica Bank's motion for summary disposition under the Michigan court rules in lieu of filing an answer to plaintiff's complaint. Oral argument requested. And by the way, I've heard the oral arguments are going to be scheduled for, I think it's February 22nd. Matt Wilk on X. How you doing, buddy? Good to see you. As you guys might know, right now at this very moment, Kristina Karamo herself is up LARPing in Houghton Lake, where they are pretending they're holding a state committee meeting. Apparently, they have voted to keep Kristina Karamo as chair, which is funny. I'm sure tomorrow night we'll talk more about all the goings on at the pretend state committee meeting today. But at the end of the day, the long story short, it's an illegal meeting, so who cares? But there are going to be some details I want to talk about. But anyway, let's get to it, folks. Let's read this response from Comerica Bank. Spoiler alert, a lot of it's to say that Dan Hartman is an unbelievable moron. But here we go. Defendant Comerica Bank, through its counsel, Miller, Canfield, Paddock, and Stone PLC, very, very prestigious law firm, moves for summary disposition under the court rules or in the alternative C10. By the way, Matt, if you want to come on the stream and you're available, let me shoot you the stream link right now. So if you want to join us, you're welcome to. If you're not, I totally understand. This is totally unannounced, so I will just shoot this over to you right now. If you want to come on stream, you are welcome to. I would have to put my headphones in, but I could manage that. Eugene Dixon says Rescue Michigan should reconstitute itself as Turmoil Michigan. Well, unfortunately, Eugene, it is true. We have not rescued Michigan. So there's that. There's apparently also a group now calling itself Save Michigan, which is not us. I don't know who's behind them, but they are apparently anti-Kristina as well. But they certainly do not share my style of emailing anonymously. I prefer to do things out in the open with my name on them. But that's just how that goes. So anyway, Defendant Comerica. Oh, Matthew's going to come on. All right, well, I'm putting my headphones then. Defendant Comerica through its counsel. Here I'm Mr. Okay, I read that already. For the reasons stated in the accompanying brief. All right, here we go. Oh, okay, this is just the cover letter still. Respectfully submitted, yada, yada. Okay, so here's where we get to the brief in support of what they're doing. Comerica Bank is neither a necessary nor a proper party to this litigation, and it is clear on the pleadings and attachments that Comerica is entitled to immediate judgment as a matter of law. Oh, he says I need to text him the link. Dude, Matt, I'm not texting you while I'm on air. Check your email, buddy. I emailed it to you. All right. Sorry, I can't play around with texting while I'm on stream. Plaintiff, Michigan Republican Party's long-winded and perplexing complaint boils down to a request for a declaration that the Michigan Republican Party, instead of defendant, Michigan Republican Party Trust. I'm going to email back and just say emailed. All right, sorry, folks. I don't mean to text while I'm streaming here. Long-winded and perplexing complaint boils down to a request for a declaration that the MRP, instead of defendant, Michigan Republican Party Trust, owns Seymour Street LLC, which holds title to real property located at 518 and 520 Seymour Avenue in Lansing, collectively the Seymour Street properties. That's a funny thing that you could immediately infer, even from the trust's response to this lawsuit, is these defendants are so completely different. They're so unrelated. They don't have related claims. But that's what Dan Hartman chose to do. So, as Comerica says, their presence as a party in this lawsuit is unnecessary because the complaint is devoid of any factual allegation that Comerica has it up. There he is. Hey, Matt, how you doing, buddy?
Hey, Adam, how are you?
Good. Just having some fun reading through this. We just got started.
The one thing I want people to know, and I apologize that I'm at Jolly Pumpkin waiting for the Michigan National Championship celebration, is that this is dripping with this guy's an idiot.
With his
Start
what?
to finish. With the person explaining to the judge that Dan Hartman, who wrote this, is an idiot.
Yeah.
And it's dripping with this throughout it. So go ahead. Happy.
It's hilarious. Okay, Comerica's presence as a party in this lawsuit is unnecessary because the complaint is devoid of any factual allegation that Comerica has authority over or interest in the outcome of the real property dispute. It does not. Maintains a position on which of the two entities owns the property. It does not. Or that any other circumstance exists by which there is an actual case or controversy between the Michigan Republican Party and Comerica regarding the Seymour Street properties. The relief that MRP requests concerning the real property does not require the presence of Comerica as a defendant. Lynn Schwartz says, being a delegate, I received the email yesterday from Patriot Battle Axe. Never heard of it. Sounds like a Democrat or Rhino wrote the article. I've never heard of them either, Lynn, so I don't know what that's in relation to. Independently, it is undisputed that Comerica loaned the MRP an amount of money which is documented by various loan documents attached to the complaint, most notably the September 22nd master revolving note. The note. It is also undisputed that as of the date of this motion, MRP failed to make monthly interest payments on the note due in October, November, and December of 2023, causing it now to be in default of the note for more than 120 days. Oops.
That's important. It's important to stop there, Adam, because I do not think that members of the state committee were told. We've had conference call after conference call after conference call on this. I don't think they were told. They stopped payments in October, and they were issued a letter of default in December.
Yeah.
Remember, we had these two calls. It would be nice. I would think somebody would say, hey, look, by the way, we've been issued a default letter, and we're in default, and legal action is now pending, and we have to pay default interest. That's not mentioned there, but not mentioned in the state committee.
This is the way Kristina operates. The rules don't apply to her. The laws don't apply to her. Doesn't need to notify anybody. There's no budget committee. I say whatever I please. I'll do whatever I please. That's their attitude, and this is it catching up to them. So it goes on. The court. Oh wait. Okay. Nothing interesting in the footnote there. Other than there's an exhibit where they've made demand for payment in full of the note. The complaint fails to sufficiently explain how the party's distinct obligations on its note with Comerica impact the ownership dispute over the Seymour Street properties at the center of this case. Nevertheless, the party has not adequately articulated a cause of action against Comerica about its obligation under the note. Instead, and this is to Matt's point, the party asserts contradictory, befuddling, and factually unsupported allegations about the note and other loan documents. For example, one of the documents is either not valid, was revoked, was never revoked, simply does not exist, or that the signatory lacks authority to sign it. The allegations are so poorly and inconsistently pled that it is almost impossible to interpret what the MRP claims regarding its obligation under the note.
Yeah, it's absurd. And this was part of what Dan Hartman had said to people is, we can't figure it out, so we're going to go into court and somehow plead this, and the judge is going to figure it out. That's not how the law works.
Yeah.
That's not how the court process works. They're not going to help you. And this response, which lays out the facts, much like the trust response did, makes it very clear that everything Dan Hartman said was wrong.
Yeah. I mean, that's what Dan Hartman keeps saying. People keep telling me, you just don't hear him out. You haven't heard Kristina out. He says over and over and over again, we're just asking the courts to solve this very bizarre, confusing situation that we find ourselves in. To the extent the MRP alleges that the note and other loan documents are invalid, the parties would need to be restored to the position they were in before the execution of the note, which would require the Michigan Republican Party to return to Comerica the money that it loaned under the note. Oh, yeah. There's that little thing right there. Yeah, if you think this isn't a valid loan, then give us the money back. Give us the money back.
Well, look, that is one of the common arguments that was made in 2008, 2009 about flawed loan documents. My loan documents are flawed, so therefore I don't owe you the money. That's simply not true. Did you get the money? Did you give it back? whether you own the building or don't own the building, or it's owned by this or that, it doesn't matter. You still got to give the money back. And now that they've defaulted on the line of credit, going into a 2024 election season, they now have no source of money to do the things that state parties need to do to win elections.
Yeah. And that's what this is really all about, is preventing the state party from being able to win any elections.
Right, exactly.
To the extent they, okay, wait, I already read that. Indeed, glaringly absent from the complaint is any allegation that the Michigan Republican Party did not receive the money from Comerica identified in the note. Of course, it is undisputed that the party received the loan. Moreover, to the extent that the party alleges that the note does not contain authorized signatures, this is that nonsensical BS in the complaint, the MRP is ignoring its own resolutions and incumbency certification of the Unincorporated Association Authority to Procure Loans, also dated September 2nd, 2022, is attached as Exhibit B, the authority resolution. The authority resolution, which is part of the note package the MRP returned to Comerica, provides that either the chair or chief of staff had the authority to sign the note. Notably, they both did. Paul Cordes signed the note. The MRP nowhere alleges and could not allege that Mr. Cordes was not the chief of staff as of September 22nd, 2022.
Right.
Melissa Caron says this lawsuit is embarrassing. Yeah, it's very funny, though.
Well, in their filing, and you look at it, they attached the first few pages, but not the last page, which was the document signed by Weiser and Cordes saying Cordes can sign the note.
Yeah.
Look,
they made a big deal about that too, saying, "Oh, Paul Cordes didn't have the authority to sign." Well, here it is, Exhibit B.
Right.
Whose signatures are these? Oh, there's Paul Cordes's, and there's Ron Weiser's.
I mean, it's so nonsense. Again, it's too cute by half, just like the rest of the trust stuff. We're going to allege X, Y, or Z. We're going to make them prove it. They prove it in 10 seconds. Now what?
Yeah. Okay, let's keep going here. In short, the party does not, when I say party, I'm talking about the Michigan Republican Party, does not sufficiently allege that Comerica is a proper or necessary party in this dispute between other parties or other entities' overall real property and trademark rights, nor has it adequately articulated a cause of action against Comerica about its obligation under the note. For all of these reasons, and those stated in more detail below, the court should grant summary disposition in Comerica's favor under the court rules and dismiss it from the action. Alternatively, in the event this court considers evidence outside of the pleadings, summary disposition is still appropriate under the court rules, as there is no material dispute, fact dispute, and discovery does not stand a fair chance of uncovering factual support for a tribal claim. So, facts as alleged in plaintiff's complaint. First, I have this whole couple paragraphs here. Allegations unrelated to Comerica, because they're trying to do two separate things at once in one suit. So there's all these allegations about Comerica. We don't have to read through all of them, or about the building. We talk about the building a lot. Oh, this is a funny footnote, though, right here. Where's this from? Yeah. Chief of Staff as of September 22nd, 2022. Footnote. On Saturday, January 6th, 2024, the Michigan Republican Party Committee is reported to have voted Chair Kristina Karamo and General Counsel Dan Hartman out of their respective positions within the Michigan Republican Party leadership. I don't know why they misspelled Republican there. But whatever. Thus, it is unclear whether the continuation of this lawsuit is authorized by the Michigan Republican Party. Its initiation wasn't authorized by the Michigan Republican Party, so there's that.
Right. And the guy, Dan Hartman said on a call Friday, 2 Fridays ago, that if he was told by a majority of the state committee to drop the suit, he would refuse to do it. That just is simply lacking understanding who your client is, who you represent. You don't represent Kristina Karamo individually. You represent the party. If the party says drop the suit, drop the suit. That's the basics of the ethical obligations of an attorney representing an organization. The jails were filled with guys who would listen to a person and not understand who the client is. It's like ethics, rule 101.
Yeah, he literally told the party, I will refuse to serve my client ethically, is what he basically said. Melissa says, so this just sets us back even more with the presidential primary election 2 months away. Yep. That's right. Anyway, so there's all these allegations unrelated to Comerica about Seymour Street properties, and of course they just keep saying Comerica has nothing to do with any of this. Comerica has nothing to do with any of this. This complaint is otherwise devoid of any allegations Comerica has anything to say about which entity owns the intellectual property of the party. Now, allegations related to Comerica. Plaintiff asserts superfluous, conflicting, and factually inadequate allegations regarding its obligation under the note and other loan documents with Comerica. Dripping with contempt for Dan Hartman.
Because, you know, these guys at Miller Canfield, they're big time, really good attorneys, and they experience this a lot. And there's a professional way to sort of defend against the claim that you owe the money back. This isn't it. This is, you know, my dog ate my homework. I don't understand. And it's so poorly drafted. And the reason why it's poorly drafted is the state party cannot afford an attorney. Instead, they got Dan Hartman to do it. As we talked about last time, Dan Hartman is a fact witness and is going to have to be excluded from representing the party. I don't know who they're going to get to do it. The rest of their staff is either disbarred attorneys or attorneys who never got past the bar in the first place. So what are they going to do at this point? I have no idea.
I can't imagine an attorney taking the case. Oh, no. This case about you trying to recover the money you can't pay back because you defaulted on a loan because you have no money. Oh, no, yeah, I'll take you as my client.
Right. Well, they would, and they'd say, okay, it's 150 grand up front. She doesn't have 150 grand. She doesn't have 15 grand. So she's not going to get anyone to do it. And it's the facts of the case are so horrid for her that this is an attempt to throw it against the wall and see what sticks, and it doesn't work that way.
Yeah. All right. So here we get back to Comerica's response here. Comerica and the party entered into a financing agreement documented by the note, a letter agreement dated April 27th, 2015, a negative pledge letter dated September 28th, 2006, and other documents, instruments, and agreements executed between the two parties, collectively the loan documents. As of November 17th, 2023, the Michigan Republican Party failed to make monthly interest payments on the note due in October and November 2023. The party's failure to make timely interest payments constituted an event of default. Subsequently, on November 22nd, Comerica sent a default letter dated November 22nd, 2023, the default letter, to MRP's general counsel. The MRP failed to respond to the default letter and then failed to make its December payment on the note. The failure to make its December payment constituted an additional event of default.
And that's important to know. That's important to note because that decision to default on the note, they have the money to pay interest. Interest on $500,000, interest only, is not that big of a payment. They have the money to do so, and they refuse. Query, who gave them the authority to stop to default on the note? Because it wasn't the budget committee, and it wasn't the overall state committee. Did they make a decision on their own to default on a loan with a major bank in Michigan that had always provided to them a line of credit to help their electioneering efforts, and they just decided on their own, we're just going to default on it for want of whatever it is, $6,000 payment or $5,000 payment, or whatever it is.
The rules don't apply to me. The law doesn't apply to me. The loan agreement doesn't apply to me. I can do whatever I want. That's their attitude.
Exactly.
It's the attitude of a con artist, which is what they are.
Effectively, yes.
Okay, so where were we? Has not responded to the demand letter, and as of the date of this motion, has been in default for over 120 days. The MRP, in a bit of sophistry, attaches the note and asserts that nothing therein indicates that the MRP authorized the indebtedness. However, the party ignores its own authority resolution attached as Exhibit B, which states on the first page that any one of the following: Chairman or Chief of Staff of the Association, Michigan Republican Party, and Michigan Unincorporated Association, the authorized signers, are authorized for, on behalf of and in the name of the association, to negotiate and procure loans from Comerica Bank, execute and deliver any and all notes, evidences of indebtedness, and other agreements, and so on. See the court rules. Quote, if a claim or defense is based on a written instrument, a copy of the instrument or its pertinent parts must be attached to the pleading. Both Ronald Weiser, then the undisputed chairman of the Michigan Republican Party, and Paul Cordes, then the undisputed MRP Chief of Staff, signed the authority resolution. Willfully ignoring this authorization and the fact that Mr. Cordes, in its capacity as the party Chief of Staff, signed the note, the MRP complaint summarily concludes that, based purely on information and belief, the note is not a valid obligation of the party. Footnote. Importantly, Section 8.6 of the note provides entire agreement amendments. This note and the other loan documents constitute the entire contract among the parties, related to the subject matter hereof, and supersede any and all previous agreements, understandings, et cetera, et cetera. On page 9, the note defines loan documents as follows. Loan documents means collectively this note and all other documents, instruments, and agreements evidencing, governing, securing, guaranteeing, or otherwise relating to or executed pursuant to or in connection with this note, or the indebtedness evidenced hereby, whether executed and delivered prior to, concurrently with, or subsequent to this note.
Yeah, and let's stop right there and talk about the phrase "upon information and belief."
Yeah.
Okay. So Dan Hartman made a big deal about this, and he used that over and over in his call. He said, "Well, this is upon information and belief." That's not what the court rules allow you to do. You don't get to allege something and say, "I think this is true." You got to disprove it. That's not how it works.
Yeah.
And in this case, they said specifically, "We think the note is not properly authorized," and they left off the page that they signed that properly authorized it. So that's a big problem. Now, we'll get to the end of it. We'll talk about what Comerica asks for in relief, which is different than what the trust asks. But when the judge looks at it and says, did you do a reasonable amount of due diligence to determine whether, I don't know, whether you signed the note or not? The answer is you didn't. It's right here. Now, Judge, what are you going to do at that point?
Yeah, the whole idea of information and belief is you have some reason to suspect something. You can show the court something to say, I have a reason to think this might be the case. Not, I have no reason to think, and by the way, I'm also withholding evidence that proves I know I'm full of shit.
Right, exactly. And when you have an organization and they have signed documents, you can't say, well, I couldn't find them, I didn't look for them, dog ate my homework. You can't do one of those things. That knowledge is imputed upon you. Any good lawyer, any reasonable lawyer knows this. Unfortunately, the people who are guiding the party don't include any of that. There's no reasonable lawyer in the group. There's a bad lawyer, a disbarred lawyer, and a guy who never was a lawyer. So,
all right, let's keep going. So the MRP further claims granted only on information and belief that the note violates the letter agreement, or in the alternative that the letter agreement was waived. The MRP also alleges that the letter agreement was never validly executed with authority of the state party. Ultimately, the party asserts, again, only on information and belief, the letter agreement has been waived, merged, or revoked. Finally, the party alleges on information and belief only the negative. This is them drilling this point home to the judge. The repetition is critical. Like, here it is again, on information and belief only. The negative pledge is either not valid, was revoked, was never revoked, simply did not exist, or the signatory lacked authority to sign it. The complaint does not allege, nor could it, that the party did not take out the loan, evidenced by the loan documents, or that it did not accept or receive the loan. It, of course, did.
Right.
Yet in its prayer for relief, go ahead.
I was saying, when you file an answer to a complaint, you're allowed to put out on it what's called affirmative defenses. And you're allowed to plead affirmative defenses and what's called the alternative. You can say, I never signed it. Even if I did sign it, it's not, the person signing it didn't have the authority. Those are affirmative defenses.
Yeah.
That doesn't apply when you're the plaintiff. It's the basics of law. This guy goes out there and says, this may be true, or this may be true, or this may be true, or this may be true. The judge looks at him and goes, you're the plaintiff. Why don't you figure it out first?
Yeah. In its prayer for relief, the party asked the court to declare that the party has no obligation under the note, the negative pledge, or letter agreement, or in the alternative, define each rights and responsibilities of the plaintiff and defendants as to each. That's from what Dan Hartman asked the court to do. Nowhere does the party state that it has returned Comerica to the status quo ante, easily done if MRP simply were to pay the loan, which is actually not so easily done for them because they have no money, or even that it will do so. The MRP additionally requests that the court enjoin any further attempts to collect on the note. That's what they asked for in the complaint, the request for injunctive relief. MRP does not, however, allege in any articulable manner, supported by plausible factual allegations, why or how it is not obligated to repay the loan. They're trying to use the court as an instrument to get out of a debt. It's incredible. It's a complete scam.
Well, look, they have not, and I will say this with very, very good authority. A budget committee member who I know was presented with the concept of filing this lawsuit, and they laid out 1, 2, 3, 4, and she raises her hand and says, hey, how about number 5? Number 5 should be raise money and pay off this line of credit. And they laughed at her and yelled at her and all these things. And she's been doing this for a long time. She's a very seasoned person. that is the right method. That's the only method. You're not going to be able to talk your way or litigate your way out of owing the $500,000.
Yeah, they're trying to sue their way out of a debt because they're con artists.
Right, exactly.
In total, this is a hilarious footnote. MRP's complaint comprises 32 allegations that are based solely on information and belief, and then they cite them all out. Amazing. The MRP's remaining scattershot allegations. The rest of the MRP's allegations against Comerica are scattershot and appear to be unconnected to its request for declaratory and injunctive relief. For example, the party asserts that in February of 2023, Comerica notified the MRP that it defaulted on the note in December 2022. The MRP also alleges that Comerica took a, quote, unreasonable amount of time to provide it with access to the account records related to the note, and that it still has not provided the MRP with, quote unquote, many allegedly required, albeit undefined, documents. Unidentified, I mean. Ben Joseph says, I skipped out of the state committee meeting for updating a Telegram group on the meeting. Yeah, I mean, that's these people are. They're scum. I got kicked out of their call on the other night like 5 or 6 times, or more than that. Maybe it was like 10 times.
You and me both, Adam.
Yeah. Although the funny thing was I was connected over the phone, so I could still hear the whole thing. I still taped the whole thing. Right. But whatever. MRP further claims that Comerica, quote, moved credit card debts that were incurred by the prior administration to the line of credit in 2023. Then it took money from MRP-owned bank accounts to pay the amount that was due on the note. Finally, the MRP alleges that Comerica failed to provide it with documentation showing that the money it supposedly took was used to MRP's benefit, or that the MRP authorized any advances or draws against the note. As set forth below, none of MRP's allegations had a viable legal claim for declaratory relief against Comerica. Therefore, we're entitled to summary disposition. Argument. Matt, should we bother reading the standard of review?
No, skip right through that. That's cut and paste from another one.
Yeah. Comerica is not a proper defendant to the suit. In the case of an actual controversy within its jurisdiction, a Michigan Court of Record may declare their rights in other legal relations of an interested party seeking declaratory judgment, whether or not relief is or could be sought or granted. Where no case of actual controversy exists, not only has the plaintiff failed to state a plausible claim for declaratory relief, but the circuit court lacks subject matter jurisdiction to enter a declaratory judgment. To allege an actual controversy, it is essential that a plaintiff, at a minimum, pleads facts entitling it to the judgment it seeks and proves each alleged fact, i.e., a plaintiff must allege and prove an actual justiciable controversy.
Right, and it's very important. They are the plaintiff. They have to prove everything they say. Dan Hartman, who confuses the role of a plaintiff and a defendant, not shocking, is saying, I'm going to file a suit with these wild claims, and then I'm going to make Comerica prove which one of my wild claims is true. That's not how it works. It's completely backward. Any good lawyer would know that. And as a result, you're looking at, like I said, sanctions, and we'll get to the end and we'll see what they have to say.
Yep. Comerica should be dismissed from this lawsuit because the MRP has not sufficiently alleged an actual justiciable controversy within it. The main disputes outlined in plaintiff's complaint, upon which it seeks declaratory relief, about which entity owns the Seymour Street properties and whether the MRP's trademark rights have been infringed, are controversies that exist exclusively between MRP and the trust. They have nothing to do with Comerica. The absence of factual allegations in the complaint, to the contrary, confirms this fact. Specifically, the party fails to present any factual allegation that Comerica has ever attempted to assert a position about the control or ownership of the Seymour Street properties. Yeah, they're trying to do 2 completely different things in one suit. First, we want to steal the building, and we want to escape the debt. They're 2 completely separate things. They filed in one suit for no reason. The complaint is further silent as to whether Comerica has any interest in the outcome of the dispute or whether it has even announced a position on which the 2 entities believes it owns the property. The MRP also fails to sufficiently explain how its distinct obligations on the note discussed below are in any way associated with the ownership dispute over the Seymour Street properties. In the same vein,
I'll pause you for 1 second there because
Dan
Hartman came out and said something that was idiotic, which is not shocking. He said, well, if we own the building, we can just give the building to Comerica in lieu of the debt. No, you can't. No, you can't. And whether people would make this argument, and I did a lot of this work in and around the Great Recession, and people make this argument all the time. And the analogy I would use is this: Adam, I'm going to give you $20, or I'm going to ask you to lend me $20, and I'm going to give you my watch. If my watch breaks, I don't not owe you the $20 back. So if flaws or whatever in and around the collateral, it doesn't matter. You still owe $500,000 to Comerica.
Yeah. On Facebook, John Smith says they made claims about this as about party brand as well, the expired trademark names. Yeah, all the trademark stuff is complete gibberish. It was a trademark for that logo they used for a time. That's all it was. You can't trademark Republican Party. And it's all attempt to try to, the idea that they were going for is, let's try to get a court to give us something that we can say gives us the ability to prohibit county and district parties from calling themselves local parties if we don't want them to. Let's give us a way to send a cease and desist letter to the MIGOP watch email list because they're using the word Republican, et cetera. That's all that BS was about, and has no relation to trademark law whatsoever. It's complete gibberish.
Right. They have a guy who, Jim Coppice, who's not an attorney yet, puts 3 or 4 law degrees in his signature block, and he is, we're going to negotiate and we're going to file a lawsuit so we can negotiate this. That's not how it works. And when they filed it, they went against, he's now going against real professional attorneys. And if you Google Mr. Coppice's name, Google James Coppice, you see he's been the defendant over and over again. When he tried this strategy and it didn't work, and it hauled him into court and he lost.
Amazing. In the same vein, the MRP wholly fails to allege that Comerica had any involvement in or creation of the DBAs or any other conceivable connection to the alleged infringement. The trademark rights, this is more of the trademark stuff. Blah, blah, blah. Comerica is caught in the crossfire of a dispute between other entities and is properly named here. The court could still grant the MRP's request if warranted for a declaration about Seymour Street, the rights of Seymour Street belong to the Michigan Republican Party, without the presence of Comerica as a defendant. In short, the MRP has failed to plead any facts, let alone plausible facts, to properly state claims against Comerica upon which relief may be granted as a matter of law. Therefore, Comerica should be dismissed from this lawsuit pursuant to the court rules. Alternatively, if the court were to consider materials outside the pleadings, including records incorporated therein or presented by any other party, Comerica is also entitled to summary disposition under the court rules because no amount of factual development will change the undisputed fact that Comerica is not involved in the disputes about ownership of Seymour Street or whether the MRP's trademark was infringed. On Facebook, Emma Birch says, Kristina said the Comerica lawsuit was only to retrieve the original line of credit documents, nothing related to money. Is that true? That's not a way to obtain documents. Go ahead.
Number one, that is absolutely not true. How do we know that? They attached the note to their own complaint. They attached that stuff. So they had it. How do you have a note? You have the letter agreement. You attach them to your own complaint, and then you say, I don't have the documents I need. It just doesn't. It just there's nothing here that makes any sense whatsoever.
Yeah, she's a bullshit artist, and she just can't keep her claims straight. MRP fails to adequately plead a cause of action regarding its obligation on the note. Even if Comerica were a proper party in this dispute, the MRP fails to sufficiently state a cause of action against Comerica related to its obligation on the note. Court rules require a complaint to include a statement of the facts without repetition on which the pleader relies in stating the cause of action with the specific allegations necessary reasonably to inform the adverse party of the nature of the claims the adverse party is called on to defend. In other words, your complaint must make sense. You have to actually
claim some reasonable sense. You got to lay out a set of facts that would allow you to get out of paying the note. They haven't alleged that. They haven't alleged a set of facts. They're not close. Is what they're saying. It happens to be true as well. Yeah.
So now there's another sentence about the Court of Appeals saying the same thing. The MRP's allegations regarding its obligation under the note are so factually deficient and contradictory that they do not reasonably inform Comerica or the court of the nature of the MRP's claim or apprise it of the essential facts necessary to prepare a defense. In other words, this is so retarded we can't even understand what he's trying to say. Which John Dunlap, who's an attorney in my county, had looked over and he prepared a memorandum about their lawsuit. He's like, your head spins trying to understand what in the world they're even talking about half the time. The MRP asserts so many alternate theories based solely on information and belief that it is difficult, if not impossible, for Comerica to decipher what actual controversy the MRP alleges regarding the note, such that trying to understand MRP's claim is like trying to nail Jello to a tree.
Money shot.
The complaint does not appear to contain allegations about the note that would form a cause of action of any kind against Comerica. But as best as Comerica can translate from the plaintiff's severely flawed pleading, the MRP seemingly alleges that it is not obligated to pay on the note because the note and other loan documents are either unauthorized or non-existent. Primarily, to the extent the MRP asserts the note is unauthorized, the complaint is bereft of any allegation that the MRP did not receive the money from Comerica on the note.
Right.
I mean, they're just repeating themselves at this point. It's the same thing.
Right. And
we gave you the money.
Go ahead. Right. That's an important thing because this argument was made. It wasn't authorized, but you got the money and you spent it and you didn't give it back. That is much more important to a judge and under the eyes of the law than whether authorization was there. Because if it wasn't authorized, like if I'm sitting and I find $500,000 in my bank account and I call my bank and I say, where did I get this from? I wasn't entitled to this. Give it back, no big deal, right? But that's not what they're saying here. They're saying we got the money, we spent the money, it wasn't authorized, so therefore we don't have to pay it back. That's just not how the law works.
Yeah, it's the way crooks work. Where were we? Oh, yeah. Further, to the extent the MRP claims that the note is invalid or unenforceable for whatever reason, the proper equitable remedy that it should have sought is rescission of the note, i.e., the equitable undoing of the note to return the parties to the position they would have been if they had never formed the agreement. Give us the money back. However, the MRP has not alleged any specific equitable grounds on which it could obtain rescission, including misrepresentation, duress, undue influence, mutual mistake, and so on, seeking various cases justifying rescission. Comerica suspects the MRP does not seek rescission of the note because that require the MRP to restore Comerica to the same position that it occupied before the note was created, i.e., to return to Comerica the money that it loaned to the MRP. And again, it's Comerica saying to the judge, look, judge, they're trying to keep the money that we loaned them. They're trying to steal our money. That's what's happening here. It's plain as day. The MRP's pleading infirmities continue with its failure to attach its own resolution, reflected by the authority resolution attached to Exhibit B. By ignoring its very own resolutions, the MRP incorrectly alleges that nothing in the note signifies that MRP authorized the indebtedness. This is that other BS argument that, well, Ron Weiser did it and therefore doesn't apply to me because I'm the new chair. Like as if agreements that a former CEO signed don't apply to a new CEO. However, the two-page authority resolution executed at the same time as the note confirms the opposite. Indeed, these two pages explicitly authorize the chairman or the chief of staff to execute notes or other evidence of indebtedness on the party's behalf. And without doubt, the authority resolution contains both the signatures of Ronald Weiser, the then chairman of the MRP, and Paul Cordes, then chief of staff. MRP's allegation that it did not authorize the debt on the note therefore fails as a matter of law.
And that is a one phone call conversation. You pick up the phone, you call your bank, you say, can I please have a copy of the authorizing resolution? I don't have a copy of it. And they will send it to you and say, here you go. Instead, we file a lawsuit claiming that it doesn't exist. It, of course, does exist because Comerica is a professional bank. And they say, yeah, here's where you authorized it right here. Yeah.
Did Kristina really think they're not going to be able to produce this document? The bank, Comerica Bank?
No. I think she's, like I said, I think this is a Jim Coppice special. It's got his fingerprints all over it. That he's going to sue a bank and then get to negotiate, and it just doesn't work that way.
Yeah. In addition, the MRP's conclusory assertion that on information and belief only, the note is not an valid obligation of the MRP is insufficient to state a cause of action. Matt, would you like to explain what the use of that word conclusory in there is all about? It's about kind of letting the judge know a certain something was not done properly.
Yeah, so you're allowed to file a pleading in the state of Michigan. It's called notice-based or fact-based, right? So you say, this is my claim. But if you're going to allege a fact, the fact has to be true. You just can't say, I conclude I don't owe the money without a basis to not owe the money in this particular case. So when you put in your pleading and and I don't owe the money, you have to have a basis before that. Otherwise, it's just conclusory, right?
Yeah.
It's like I can't say, the Lions were robbed, right? I have to provide the pleading the facts underneath it before I can say that. And they didn't, because there aren't any. Because one of the things you can't do is go into court and just, which he did, and flat out lie and say this doesn't exist. You have to lay the foundation for that fact. They didn't do it. So he just says, look, they made a conclusory statement. That's not a sufficient way to avoid summary judgment.
Yeah, this is a flag to the judge. Hey, they're trying to get one over on you and try to pass off a legal conclusion as it's a statement of facts in their pleading. So on information or belief only, the note's not a valid obligation of the MRP, insufficient to state a cause of action. Quote, a mere statement of a pleader's conclusions, unsupported by allegations of fact, will not suffice to state a cause of action.
Yeah, that's exactly right.
There's more citations here. In short, simply adding the boilerplate phrase on information and belief does not transform a conclusory pleading into one that is factually supported, particularly where, as here, the exhibits attached to the complaint and those here too belie the contention.
And that is exactly the opposite of what Dan Hartman said on his call. He said that all he has to do is say information and belief, and he can say whatever he wants. That's simply not true.
Yep. John Smith on Facebook says, obviously this is the straw that broke the back, but Karamo failed to have a simple leadership meeting. I essentially begged her in the administration to make this happen since the administration blocked out Melinda back in early June. This administration claims people have been working against them since the beginning. 4 people that are not in the state committee were able to subvert this administration on Telegram. This is not a reason to side with the administration. It's a reason, ... Okay, it's not, John, I'm sorry, your comment was too long. It wouldn't let me see the rest of it. But I did read it, so there you go. If you want to paste the rest of it back in, I'll finish it. Okay, more case citations here. And then they go on. The MRP also asserts fact deficient and conflicting allegations regarding the letter agreement. Specifically, it claims, again, grounded merely on information and belief, that the note violates the letter agreement in various unexplained ways, or in the alternative, that the letter agreement was waived. The MRP further claims, in a conclusory manner, that the letter agreement was never validly executed with the authority of the MRP. Ultimately, the MRP sticks with its kitchen sink approach and asserts, on information and belief, that the letter agreement has also been waived, merged, or revoked. In like fashion, the MRP hypothesizes, on information and belief, that the negative pledge is either not valid, was revoked, was never revoked, simply didn't exist, or the signatory lacked authority to sign it. Parties have a right to raise inconsistent theories, but it is not unlimited.
Right.
Another smackdown right there.
Right.
When the contradictory assertions are so voluminous and amount to mere conclusory assertions based solely, they keep hitting this over and over again. Conclusory. Based solely on information and belief, as here, they are not enough to state a claim.
Right. If you have a set of facts that support your position, lay them out and make your case. You don't. You don't get to say, I suspect that blank may have occurred. And therefore, if blank has occurred, I don't have to pay the money. That's not how it works.
Yep. Mark Kerniel on Facebook asks, who is connected to the trust? The trust is current and former state party chairs and a couple other people. And we covered that more in depth on the when we read through the trust's response to this lawsuit, which was a few days ago.
Right.
And Smith says, it's a reason to side with the administration. It's a reason to remove them. Her failure is leadership, in my opinion. Her failure is everything at this point. Her failure to raise money, failure to get people together, failure not to make incendiary and stupid remarks on social media, failure not to attack donors, and now dragging the party into a meritless lawsuit that's going to cost them probably hundreds of thousands of dollars in legal fees and unbelievable embarrassment, and going to cause her to lose the election. And cause Trump to lose the election in Michigan, by the way, folks. These people who think they're Trump supporters, they're not. They're trying to lose the election. Anyway, where were we? Okay, there's a big parenthetical comment citing the thing I just read. But there's a footnote here. To be clear, the note contains the agreement of the Michigan Republican Party to repay the money owed to Comerica, not the negative pledge or the letter agreement. Finally, the Michigan Republican Party asserts various directionless allegations against Comerica that are seemingly unconnected to the rest of its allegations about the note and to its requests for declaratory and injunctive relief. But even if the court were to accept these allegations as true, they still fail to sufficiently assert that the MRP is not responsible for payment on the note, that Comerica has some sort of legal duty to the MRP that it breached, or that Comerica engaged in any other sort of wrongdoing. On the whole, Plaintiff's complaint is devoid of any factual allegation that could suffice to state a cause of action against Comerica, declaratory or otherwise, and no amount of factual development can save the plaintiff's deficient pleading. Accordingly, the complaint should be dismissed in Comerica's favor for failure to state a claim on which relief can be granted under the court rules. Alternatively, if this court considers evidence outside of the pleading, summary disposition is still appropriate under MCR, as there is no material fact dispute, and discovery does not stand a fair chance of uncovering factual support for a triable claim. Yep.
Now, there is something that's very interesting there, and I want people to understand this. I want people to understand that Comerica did us a solid as Republicans, because in my history, when I was representing financial institutions and they were sued, we would counterclaim for the money back. We would say, okay, if that's the path you want to take, by the way, not only do you owe us the money, but we want it right now. And they have that capacity because they're 120 days past due. They can very easily say, you owe us $500,000, whatever the number is, plus attorney's fees, because that's in the document. And that, as we talked about last week, because we are an unincorporated association, take that number divided by 107, whatever it is, and everybody owes the money. So that's $5,000 to $6,000 to $7,000 per state committee member. Comerica didn't ask for it, but they can. They didn't.
I wish they had. Solid. I think a solid would have been of suing for it and burying Kristina alive.
Well, I think that it's obvious that would be their next move. I hope state committee members, if anyone are watching, that they've gotten out of the ridiculous thing they had up north. They say, hey, look, this is all well and good, but we owe the money back.
Yeah. Mark Herniel says Trump is up in Michigan by 10 points. Well, and that's, I guess, to my remark about how Kristina is going to destroy the Michigan Republican Party and cause Trump to lose Michigan. Well, first off, Mark, a lot can happen in 10 months. Secondly, even if Trump is up in Michigan, how about the U.S. Senate race? How about the state house? You don't think having an effective state party matters because Trump is up by 10 points? And by the way, wasn't Trump up? Did we all feel pretty good going into the 2020 election? So I don't know if I would trust those polls. Just saying.
Well, more particularly, we have a very important race in the state house,
the
25th House district. Right now, if we win, we can stop Gretchen Whitmer's agenda through the end of 2024. We should be knocking on doors to support Josh Powell. He's the Republican candidate for that race in Westland. I know the people locally are working very hard at it, but instead, all the other people are wasting their time fighting, doing things like this, suing people, having these ridiculous meetings, when instead we should be trying to win an election. You know what the Democrats are doing? Trying to win an election.
Yep. And Mark Colonel says, state committee cannot be sued. State committee has been sued. State committee's had judgments put in against them. Right. State committee most certainly can be sued.
They have been sued, and not only that, they have lost. They have lost sanctions in the Hillsdale case.
Yep.
That is real. And
there is an active contempt of court order against every state committee member right now.
Correct.
Yep. Emma Birch says, does Kristina have to get state committee approval before entering into these lawsuits? She should. She didn't. She broke the rules. If state committee's on the hook, shouldn't they have a say? They should. And those state committee members who are smart voted to remove her for just that reason the other day.
Well, and I think
those state committee members who are stupid were up in Houghton Lake honoring her today.
Right. And I would just have simply walked around with a big hat, and I would have said, everybody here, please write me a check for $7,500, or actually double, because there's only half of them there, $15,000, and you get to pay off Kristina's debts. And the answer to Emma's question is, that is a defense. I don't know which form it's going to take, but I know that some state committee members have asked, should we file something in the court saying, Your Honor, we didn't authorize this lawsuit? And I think that's pending the results of what happens on January 20th and other times, and see what the RNC has to say. But I think they're going to walk right in and say, hey, we didn't authorize this. We didn't tell anyone they could do this. And like I said, Dan Hartman said specifically, even if more than half of the state committee tells him to drop the lawsuit, he won't until Kristina does. That's just basic failure of ethics and understanding who the client is.
Yep. John Smith asks, if Trump loses in Michigan, and that's KK's fault, so if he wins in Michigan, is that KK's doing? Well, I mean, come on, here's the thing. There's many factors in a campaign winning or losing. It's the campaign itself. It's outside sources. It's the whole team. It's the HRCC and the SRCC and the state party and the NRCC and the RNC and the Trump campaign itself and all those supporting PACs. Every little bit makes a difference. The thing that's so important about the state party, by the way, and I'll be the first to say, the state party does not have a history of spending money very wisely, but better spends money than spends no money because it doesn't have any money to spend. And one thing in particular the state party can do is they get a very excellent postage rate that other entities don't get. So it's ideal for the party to drop mail in, say, Josh Powell's race, which they can't do now because the state party is broke.
Right.
So if he loses by 20 votes, 30 votes, 40 votes, that will be on Kristina, because she could have helped out if she wasn't busy attacking county parties across the state. Anyway, conclusion. For the foregoing reasons, Comerica respectfully requests the court grant summary disposition in the alternative favor, dismiss it from the case, and award any other relief the court deems appropriate under the circumstances. I think they should have asked for attorney's fees. I think they should have asked for sanctions. I think they should have countersued. This is, you know, as you say, a solid for the GOP as an institution, but I kind of wish they'd buried Kristina harder. But that's it, folks. Only other thing left here is this letter to Dan Hartman, informing them of their notice of default and just making sure that the world knows that Dan Hartman was informed of this debt. They're choosing not to pay it. We looked at Exhibit B already. That's the
well, and more particularly, did they, when you got a letter of default, did you tell your state committee members about it? No, you did not. Did you tell the budget committee about it? No, you did not. You just defaulted on a debt. You think that you can make any decision you want. That's just not how corporate governance works. Now, I've been a member of boards before. I've been the president of boards before. And when I do, I say, well, guys, what do you think? What do you think we need to do? And if you get outvoted, you get outvoted. But she doesn't, you know, Hartman and Kristina don't feel that way. And they take their guidance from all these unelected people like Jim Pappas, non-lawyer, Robert Owens, disbarred felon lawyer. You know, you get the results you're going to get.
Yep. Mark Kerniel says, we cannot stop Whitmer. Adam pointed out before, when we had controlled the Speaker of the House refused to allow us to impeach Whitmer. Well, Mark, I mean, even if we did impeach Whitmer when we had the majority, you still need 2/3 in the Senate to actually remove her. It would have beat us to win the election, which we didn't do. That's too late. Betty Nelson asks, has the National Republican Party taken a stance on KK? Not yet. I've heard they're going to. I hope they will. They really need to. He also says the state party has been self-funded for years. Correct. I mean, where else would the money come from? It comes from their donors and from, you know, typically very wealthy donors, but not entirely.
Well, I mean, then Kristina said specifically, I will raise $50 million. She didn't raise 50. She didn't raise 5. She didn't raise $500,000. She is at 99% failure rate. What are you going to do at that point?
Yep. Emma Birch says, as acting chair, can Melinda withdraw the party from the lawsuit? She can try. That will tee up this case to be a forum for deciding this question, by the way.
Oh, that's an important thing to talk about.
The
MRP trust did not set a hearing date, because you're allowed to, as the respondent, set a hearing date on your motion. Comerica did. February 22nd, I think.
I think so, yes.
So that's after, I think, some activity will take place in and around seeing who, you know.
There will be county conventions, but not a state convention yet.
Right.
Not the district conventions.
Not the district conventions. That's correct.
Yep. John Smith says, then focus on getting conservative state reps to elect a conservative speaker. That's my plan. That's a good plan. Win some elections, get more conservatives on the state legislature. John
and I have talked many times. I'd love to have him. He's got a very active group there in Hillsdale County. I would love to have him come out to Westland and let's knock doors, because there's a lot of commonality between that group of people, those groups of people, and they can speak the language and say, hey, look, you know, do you adhere to this crazy left-wing Democratic agenda that Whitmer's pushing? No. How do you stop it? Elect Josh Powell.
Yep. Last question. Mark says, I got here. Is the deal late? Is Matt Wilk a lawyer? Yes, he is.
Yes, I am.
Matt, what's your specialty, Matt?
I've been practicing commercial real estate and banking law for about 25 years. I'm a proud graduate of the University of Michigan in law school. I'm gonna go try to see a national championship trophy. But I know what I'm talking about.
Yeah, this is specialty. So there you go. All right, guys, I got to run too, because I got a Christmas party to start getting ready for. So see y'all tomorrow night. I'm sure we got more to talk about on our weekly live stream. Thanks for tuning in. Thanks for joining us, Matt. And we'll see you guys next time.
Thanks, Adam.